SJC-11853, Bernard J. Martin v. Angelini Plastering, Inc., and SJC-11854, Robert M. DiCarlo v. Suffolk Construction Company, Inc.
Good morning, Mr. Ackerman.
Thank you, Chief Justice, and may it please the Court. Weston Ackerman for Twin City Fire Insurance Company in the DiCarlo case and Hartford Insurance Company of the Midwest in the Martin case. Section 15 of Chapter 152, the Workers' Compensation Act, enacts a simple and straightforward rule of priority, a bright-line rule with respect to how you allocate damages from a third-party tort suit between an employee who has recovered workers' compensation benefits and an insurance company that has paid out those benefits. The rule of priority was clearly understood for over 70 years until the Curry decision in 2011 by the appeals court.
Can I ask you a question? There was a, I think that statute was amended at some point to make it clear that loss of consortium and so forth is not part of what the insurer can recover. That's correct, right? It wasn't always part of the statute.
Yes.
The SJC at some point is the one that basically said that that was not recoverable. And that was before the statute was amended, right?
Yes, Your Honor, 1980 in the Eisner case.
And the statute read the same in the particular parts that you're stressing before and after.
Yes, there was an amendment in 1991, but I don't think that's pertinent to this.
And so what do you say about if, for example, in the course of sustaining a workplace injury, somebody suffers not just pain, suffering, and so forth, but also property damage, and a tort action is brought, and recovery is made not only for personal injuries, including pain and suffering, but also for property damage, property loss. Is the insurer entitled to a lien on that recovery too?
No, Your Honor, and the reason for that is that the statute talks about an injury for which compensation is payable. An injury for which compensation is payable is essentially a term of art in workers' compensation law.
But what if the verdict is a general verdict, and we don't know how much was given for property damage? Do we ask the judge to parse it out? Or should there be a special verdict in all those cases? Is the responsibility on the insurer to ask for a special verdict?
I think in an instance where you would have property damage, something that's not the personal injury that would fall within Section 26, you would need to separate that out. I haven't seen any case where that has come up. It would be unusual, but I think it would have to be done either through a special verdict or by having the judge do it afterwards.
Now, you say it's a term of art. Where are we to find what is and is not included in that term of art?
Section 26 of the Workers' Compensation Act of Chapter 152 talks about in detail what type of injury is a compensable injury. It has to be the employee's injury. It has to arise out of and be in the course of employment. You read that together with the definition of personal injury that's part of 26, and then you go to Section 1 for the definition of personal injury. And I wanted to be sure to mention there's also a decision by this court called Saab, S-A-A-B, in 2008. That was highlighted in the amicus brief, but not in my brief. It's 452 Mass 564, and particularly page 569. That opinion talks about what is the nature of an injury that's compensable under the Workers' Compensation Act. So anytime you have that type of injury, Section 15 would apply in our view, and you would need to give the insurance company first priority of recovery with respect to that recovery.
Was that Section 26 of the Act unamended, both prior to and after the decision which basically separated out loss of consortium damages? Eisner? Eisner? I don't know, is that the name of it, Eisner? Right.
Section 26 has been amended various times, but I don't think the amendments are pertinent to what we're dealing with.
But I just, out of curiosity, so the term of art has been the same throughout?
Yes.
Even though there was a distinction drawn by the court between the kinds of injuries?
Yes, in the Eisner case, although the court in Eisner was interpreting essentially the same statutory language that has been in the statute since 1939,
You mean in Section 15?
in Section 15, right?
Right.
Now, when this statute was enacted, do you know whether there was any custom to do specific verdicts as opposed to a general verdict?
I do not know the answer to
Did the
that.
legislature anticipate that we would know how much would be awarded for different types of injury, or was the state of the art back in 1939, was that when it was? When the statute was enacted, simply a general verdict with the amount of damages in toto?
I'm not sure what the law was in 1939 with respect to special verdicts, but I think the possibility of a property damage claim at the same time.
I'm
you're
putting
making
aside property
personal-
damage. I'm talking about the crux of this particular case, which is pain and suffering. I mean, today, one could, although it's unusual, ask the jury to distinguish between pain and suffering versus other types of damages. But I'm trying to think in terms of understanding the intent of the legislature at that time, whether that would have been something that they would have contemplated, or whether they just would have assumed that it would have been a general verdict and you would know only how much the plaintiff received and you wouldn't know how much was allocated to different kinds of damages.
I think, Your Honor, based on the way the statute was drafted, they were assuming there would be one sum recovered. The statute talks about a single sum recovered, and then in 1943, they amended the statute to define it a little bit further as total sum recovered. Eventually, it became gross sum recovered. They're talking about a single sum being recovered for the injury. They're not contemplating any sort of dividing up of the injury, as Justice Agnes explained in his opinion.
So would there have been at that point a difference in the verdict if a loss of consortium was part of the damages?
Actually, back in 1939, it appears that loss of consortium probably was not recognized in Massachusetts at that time. There's some older decisions. The Lombardo decision goes into this in some detail, explaining the history of it. But there were some somewhat inconsistent decisions back in 1908 and 1909. But the general thrust appears to be that loss of consortium was not a recognized cause of action back then.
Do we know when it became one?
Became one, I believe, in 1973.
We'd also, I don't know this for a fact, but because loss of consortium goes to somebody else, it may be that that wouldn't have been part of a general verdict anyway. In other words, it would have been a verdict for a different
That's the
plaintiff.
question.
Yes, I would think the verdict would be separate if it's a verdict for the spouse as opposed to a verdict awarded to the employee himself or herself. And this court's decisions, and even the appeals court's decisions prior to the Curry decision, made clear that the understanding of the statute for many years was as a rule of priority, where the employee's recovery would go first to the insurer, and then once the insurer was reimbursed, the employee would get the excess. For some period of time, the insurance company would even get part of that excess. They would get a fifth of the excess. But going back to this court's decision in the Meehan's case, it talked about how the insurer was entitled to reimbursement for any amount that it might recover, and all the way back, all the way up to the Road decision in 1993, where this court said that this court had consistently recognized the insurance company's entitlement to full reimbursement under Section 15, and until an excess recovery exists, the entire recovery was for the insurer. That's what the court said this court said in the Road case. And even the appeals court in Taylor in 1993 and in Halton, which was Justice Ireland's decision in 1996, the appeals court read the statute exactly that way up until the Curry decision.
Now, your brother and sister, I assume, will come up and say that the key focus should be compensation and not recovery, and you can't be compensated. That's if the focus is on compensation, and since workers' comp does not compensate you for loss of pain and suffering, that it's not appropriate to provide pain and suffering damages to pay for lost wages and other types of worker compensation. What's your response to that?
What this court has said in the past, Your Honor, is it's not an apples-to-apples comparison. You don't look at the damages and divide them up, and Bongiorno and Eisner speak to this. Eisner speaks to this as well. You don't look at whether, in that case, it was damages for wrongful death, and they were actually punitive in nature at that time. And you don't look at those damages not matching up with what you get in workers' compensation. Rather, it's a rule of priority that looks at if it's the employee's recovery for the same personal injury that's a compensable injury, the insurance company gets the first share of that money up until what it is paid.
Ask you to focus on some language in Section 15 that may be unusual among this type of, and you could tell me, is it unusual among this type of provision, that appears to vest some authority in the judge reviewing a settlement where it's unclear who's getting what, to indicate what amount, if any, the insurer would be entitled to out of such a settlement. This is similar, just to give you a hint of where I'm going, to the statute in Vermont, which has this language, unlike many other places do. And there, they view that as significant to the authority to indicate what goes, what is not compensable and under the statute, under 15, and divide it up in that way in order to decide what is excess and what isn't. How do you view that, the significant, why is it there, if not in order to make a determination regarding what is compensable and what is not, and therefore what is excess and what is not?
Your Honor, the if-any language was construed by this court in Rhode and also by the appeals court in Taylor, and they rejected the argument that you could use those two words to eviscerate the earlier language in the statute, which says the sum recovered or the gross sum recovered is what goes to the insurance company. The if-any language applies in a limited, narrow, rare circumstance where all of the recovery reasonably might go to some other claim that is not a claim that falls within Section 26.
Is
So
it
if
like
all
here?
of the recovery went to property damage or all of the recovery went to loss of consortium, as the Halton case talks about, that might be a rare circumstance where the if-any language would apply, but the if-any language cannot be used to eviscerate the rest of the statute. The plaintiffs seem to be suggesting that you could read that language to say that in a case that had very extensive pain and suffering, you could award the insurance company zero. That would not make any sense. Those are the cases where the insurance companies paid out the most. They paid out the most for lost wages. They paid out the most for medicals. To say that in those cases, because there's a lot of pain and suffering, they get zero, that wouldn't make any sense. To go to the Vermont statute's very differently worded. It allows the court to look at what would be the plaintiff's entire recovery if this case, the tort case, went to trial, and then adjust the lien based on that. And Massachusetts in Section 46A has done a similar thing. This involves also workers' compensation, but the health insurance lien. And in 46A, Massachusetts legislature has said you can reduce the lien. It's actually the Department of Industrial Accidents that can do it under Section 46A. They have not done that. They made a very different choice, and a choice that's been in place for a very long time in Section 15.
So you can reduce the lien if the overall medical expenses are so huge, you give more to the employee. Is that what you're saying? Under 46?
Under 46A,
Yeah.
yes. Section 15 is structured very differently.
Does the record reflect why the insurers didn't seek further appellate review in 2011 when Curry was
They
decided?
did. We didn't
They
give
did,
it.
and it was denied.
Oh, it was denied.
Yes.
Okay.
Yeah, that's what I mean.
Okay. Thank you.
Thank you.
Good morning, Mr. Chief Justice and members of the court. Charlotte Glinka on behalf of the plaintiff appellees Bernard Martin and Nora Martin. The language of Chapter 152, Section 15, limits the insurer's right of reimbursement to only those amounts that are payable for an injury that is compensable under the workers' comp statute.
But historically, I mean, wasn't Curry a break with practice for decades and the interpretation of that statute for decades?
It's the first time the question had been put to the appeals court, but in practice, there had always been a recognition that there was to be a recovery by the plaintiff, the injured party, for those damages that were not compensable under the Act.
But I thought, though, after Curry, that in recognition that it was a change, the board changed its entire approach, so that which would be consistent with what Justice Cordy is saying, that it really was a break.
Well,
So I'm
that's
just saying,
true.
in practice, the board wasn't following the way that Curry decided it.
Well, there were settlement petitions that were put through where there was an allocation made, and whether there was a specific designation of that for pain and suffering damages. You're right, in 2011, the board did change its formal practice so that that was to be included in any settlement petition that was presented to the board. But in practice and in the Superior Court, the settlement petitions were always put through where there was an allocation to the insurer and also an allocation to the injured party for those parts of damages that were not compensable under the Act.
Do you think that Curry and Eisner and Rode and do you think they're consistent?
I do think they are consistent. Curry just formalized the process of allocating damages to a pain and suffering claim that clearly is not contained within the language of Chapter 152. Chapter 152 is a workers' compensation statute. By definition, it does not address the totality of tort damages that can be recovered by an injured party.
But what about the answer that I was given about Section 26 of the Act providing a term of art, regarding it as a term of art, defining it or elucidating what types of injuries the plaintiff can be compensated for, and this includes the injury itself. So even though workers' comp doesn't pay for pain and suffering is contained within the injury itself, and that's as used in the statutory language.
But Section 15 makes it very clear that the only thing that the insurer is entitled to be reimbursed for is that for which it has paid compensation.
Where does it where is that clear? Could you help us?
And that isn't the injury?
The very first phrase of the statute is where the focus should be, and that is...
Section 15 you're reading?
Where, this is Chapter 152, Section 15, the very first phrase, where the injury for which compensation is payable. And so the rest of the statute must be read through the lens of that first sentence.
So you have to take it all as a piece, basically, you're saying. You have to take that as a phrase. You don't just parse out injury. It's the injury for which it's compensable?
Correct. Exactly right.
And
So that-
injury for which is compensable, you don't agree that that's a term of art?
No, that is specific to those injuries that are compensable under workers' comp, which are, basically, the workers' comp statute is a wage replacement statute. It is designed to ensure that an injured employee receives compensation for the wages, actually only a portion of the wages, that he or she has lost. But it does not address and cannot address those other aspects of damages for which a third-party case is brought, and recovery under that scenario is not part of the workers' compensation statute.
But isn't injury, the workplace injury that it's what caused the pain and suffering? It's the actual damage to the person.
It is the actual damage to the person, but it's not the injury for which compensation is payable. The injury for which compensation is payable is the loss of earnings and paid at a percentage, and medical bills, which are paid directly to the provider, not to the plaintiff. So the workers' compensation statute does not address and cannot address.
This is the legislature drafting it. I mean, when a worker gets hurt, he says, "I was injured." He wouldn't say, "I suffered the injury of lost wages and the injury of pain and suffering and the separate injury of medical expenses." You would just say, "I was injured."
Correct.
So why should we assume that the legislature, when they wrote the term injury, meant not the layman's understanding of an injury, but a lawyer's interpretation of the various types of injuries which may form the various types of damages.
Because the legislature made the distinction in that very first phrase, injuries for which compensation is payable. And compensation is not payable for pain and suffering under the workers' comp statute.
So you're reading that first sentence to say, first of all, you've got the injury, and there might be a third party, because this is all about third-party liability, for which a third party might be liable. But then you're looking to see the whole sentence, which is for which the injury for which compensation is payable. But so you have to take each separately, although consider each in relation to the other, but each has a distinct meaning, although they must be considered in relation to the other in Section 15.
Correct. So it is an injury, but there are different parts of that injury. The injury for which compensation is payable, and those where the damages may be recovered for something over and above that, which are the pain and suffering damages. Similar to the loss of consortium damages, which in Eisner, it was recognized that that is a separate and distinct injury.
Well, it's an injury to a different person.
It is.
I mean, it's very different from a component of the injury that happened to the worker.
True.
So if somebody falls off a ladder, you wouldn't define the injury as having fallen off the ladder, the incident. You would define it as money paid by an insurer for lost wages and for medical bills.
The injury is the fall off the ladder, as in Mr. Martin's case.
For which you get pain and suffering and loss of use of a limb, which you can recover in workers' comp.
But you can't. You can only recover for lost wages and medical bills in that scenario. And the only way he can recover for the loss of the use of his arm and pain and suffering is by bringing a third-party action and recovering damage through that means for those injuries that are not compensable. under
Workers'
that.
comp no longer pays for loss of a limb or loss of function.
There is, yes, there is a provision that pays for loss of function, but it's not for pain and suffering. It's loss of use, loss of function.
So when Section 15 was first enacted, only the employer could bring this action, correct?
Correct.
And so what year was the employee added as a potential plaintiff in this kind of third-party action?
I believe it was in 1932.
I thought this was 39.
39, perhaps.
Well, I mean, I thought the statute was enacted in 39, but here's my question. Do you know anything about when because clearly the employer wouldn't be bringing an action to recover damages for which the employer wasn't responsible under your theory, right?
Correct.
So I guess my question is, do you know anything in terms of legislative history that when the employee was added as a plaintiff, a possible plaintiff in this kind of action, there's anything to indicate that the legislature was interested in adding on this concept of the employee then would be able to recover different types of damages that the employer would not have any lien against?
Well, I believe I'm not sure of the exact year, but I know that the legislature wanted to distinguish those types and those aspects of the injury that were compensable, and yet those that could be recovered in a separate action by the employee through an election to do so. And the intent of the statute was that the injured party should not receive something from the tort settlement that would compensate him for those same damages. And that's why there was a distinction, and that's why the Section 15 allows for a fairness hearing so that this can be brought to the court or to the DIA, and the court can determine whether it is a fair allocation. That is the purpose of the statute.
Wasn't that added in 91, the fairness hearing?
Yes, and
But that wasn't there from the beginning.
Well, no, the language, if any, has been there since the beginning. And there has been the availability to both parties to have this heard by a judge to determine whether the allocation as to all of the damages and areas of compensation, whether there's a fair allocation as between the injured party and the insurer. And that is, the court and the DIA then act as a gatekeeper to ensure that all of the parties' interests are recognized and that there is fairness in the allocation of those amounts for those different aspects of the injuries, both the pain and suffering, the loss of consortium, and the insurer for those things that were paid for lost wages and medical bills.
Thank you. I'm afraid your time is up. Thank you.
Thank you.
Good morning, Mr. Chief Justice, and may it please the court. Excuse me, Tom Murphy on behalf of Mr. DiCarlo. If I could clarify the history of the statute, it began in 1911, excuse me, when it had one sentence. Today it has 13. One sentence with a number of clauses. And at that point, it was either comp or damages from the third party, not both, one or the other. If you take the comp, we take the subrogation case, and at that point, we take it for our own benefit, was the language.
We being the insurer.
The insurer. It was actually in 1911, they called it the association.
Okay.
It was the first workers' compensation statute in the country. And so it was all, I haven't read the 1911 and 1912 cases, but it was all, the third-party case was not just the subrogation, but it was the damages on top.
So it was, at that point, the employer or the insurer stood in the shoes of the employee.
Correct.
And could get all of the same kinds of damages
And more.
that the employee could have gotten if
Correct.
the employee had chosen to go the tort route.
If he had waived the comp and taken the tort case.
So that would have included pain and suffering and
Everything.
everything.
And 2 years later, they changed it and they said, well, same thing, it's either comp or damages, not both. If you don't take, if you take the comp, we are subrogated to you, and if we recover, we'll give you 80% above what we paid. So the association retained 20%.
Well, was it, I thought it was above reimbursement.
Correct, correct.
Okay.
And then comes the 1939 statute that council talked about. And that's a critical amendment because that's when the first time the employee had the right, a conditional right, to bring the tort case. In other words, it was comp or damages, not both, unless we don't subrogate within 9 months, and then you can bring the tort case. But critically, that is when they included the language, if any. And that gets to the hearing outlined in the 9th sentence of today's version, which is outlined on page 17 of the Martin brief that outlines the 4 different criterion that's supposed to happen in that fairness hearing. And that's important because, and I think perhaps council misspoke, but this was 1939, well before consortium claims. The consortium claims came in with Justice Kaplan's Diaz case in the 70s, and then later the Farrader case, and then the legislature wrote 85X. So that's a much more recent vintage loss of consortium claims than 1939. After that, 1943, they changed a little bit, and it was the same, either comp or damages. But if you take comp and we don't subrogate, you can bring it. And if you bring it, then we'll waive the 20% fee we were going to charge you. They don't get the 20% above the excess. But it was, just to follow the timeline, 1980 was critical is when they gave the employee the exclusive right to the tort case for 7 months. And that's where we are today.
So, but do you, obviously you do disagree. Why do you disagree with the proposition of the insurers, that up to Curry, the SJC cases really were reasonably read to say the employer gets to recover what, not the employer, well, the insurer gets to recover what it paid out.
priority.
Yeah, and the priority covered everything it paid out.
Well,
And so if the settlement or the tort verdict was, you know, 100 plus 2, and the company had paid out 100, you didn't look into what that 100 was for, other than because of Eisner.
correct. I acknowledge.
You know where I'm going,
that
yeah.
Curry was, as Justice Cordy pointed out, a new step. But this is an evolving process. And if you look at the timeline of the statute, it has been a sea change of the rights going to the employee. And in addition to changing,
But what would be the change that would say, yes, you can reconcile Curry and Rode and Eisner, da-da-da-da-da, because the legislature did X in what year?
well, as to those cases, Richard and Turner in the 60s and Rode and Taylor in the 90s, those were all different issues. No one has asked you this question that Curry addressed. They speak to a lot of things, but no one has ever asked you this question before. Now, as to the word priority, that word does not appear in this statute, like some statutes. And I know this court is interested in how other states handle this matter. My brother's, one of his amici filed a lengthy brief with a matrix of all the states that read their corresponding Section 15 the way Hartford does. That's not a function of jurisprudence, that's a function of legisprudence. If you look at those statutes, they are unforgiving to an employee. They are harsh. So California and Hawaii, the entire amount. Arizona and Nevada, total recovery. Connecticut, New Jersey, Indiana, Michigan, any recovery. And Massachusetts, if any, reimbursement. And that's one thing I want to follow up with is the reimbursement. This is a reimbursement statute. And what's reimbursement but restitution or repaying that which has been expended? If you didn't pay it, you don't get it.
But I mean, couldn't you read it as being a public policy that if the employer is not the one ultimately who is responsible for the injury, because the tortfeasor is,
Correct.
but the employer's insurer has basically paid out whatever it has paid out, that the legislature is saying, no, to right that balance, we're going to reimburse the insurer for everything that they have paid out. It's not a question of what they've paid it out for, but everything they've paid it out, so that the tortfeasor is actually the one who is out the bucks and not the insurer.
Or the employer.
Or the employer.
Yeah.
Right.
But it's reimbursement only for that which has been paid.
Now, that's the part that I'm having trouble finding in the statute.
Well, I too go to the first phrase. I mean, the reimbursement bucket is cabined in that very phrase, the injury for which compensation is payable.
Do you
No
have
more,
the statute
no
right in
other.
front of you?
I do.
Could you look at the end of the second sentence, the sentence that begins either the employee or insurer,
Correct,
and it ends with such injury?
correct.
And you would read such injury as injury for which compensation is payable?
Yes.
That whole phrase?
Yes. And so the excess then would be so in workers' comp, you get 60% of your average weekly wage paid, and some percentage of the medical bills, not the whole thing they pay. There's a rate-setting commission, discount rate.
Now, if you're right, what did the statute provide for in the event of a general verdict?
Well, that's more difficult, and that's where,
The settlement allocation doesn't speak of any allocation upon a jury trial verdict.
But that's easy to solve. I mean, you told trial judges in Lorillard that they can have them identify theories of liability. So too, insurers can ask for an itemization of the damages.
And do you have any idea as to whether special verdicts were the norm in 1939 when this was done?
I doubt they were, but I don't have anything on
So
that.
if they weren't, then why would the legislature not have expected there to be a general verdict? And why would that not have been what they understood to be the sum recovered?
Well, as I said, it's an evolving process, and it's changed over the years. And I think so I don't have an answer to that question, Your Honor. But I see my time is out, but if you look at...
Wishful thinking, you're not quite there.
Okay, fine, I have more time. I think Justice Nolan in Correa versus Firestone in the 80s traced some of these in the footnotes, some of this history of this statute. And he said that and inferred the legislative intent is that they want these people to get paid. They encouraged, the structure of the changes to the statute is encouraging employees to pursue those third parties and to be paid in full. And when he said fully compensated is his word, he meant damages, not compensation in the Chapter
Of course,
152
if you pursue the suit and you get more than what you've been paid, you get it, no question about that.
But you get, and you have to pay back only what they have paid. So take a case where...
Well, actually, I'm afraid your fear of having run out of time has actually been realized, so...
Very well.
Thank
Thank you
you.
very much, and I submit on the papers.